Okay, so here we go. This is the research video for Research and Writing 2. I am Nicholas Cologne. Our topic was, we have a client that has a 6-year-old child. The client would like to have visitation with his son. Our client is incarcerated. He's serving a sentence in a local jail. The child's mother does not object to visitation. This is going to be important later with the research that we did. The jail has refused, however, to allow visitation as the administrators believe it is a security risk. The client would like the attorney to file an action to allow him to have visitation. And then our attorney wants us to provide the relevant law regarding the situation. The jurisdiction we plan to research in is going to be Indiana. So with that, we come to Westlaw. This is the database that we're going to use. Hit continue. We've started a research video for this, or a client ID named research video specifically for this. It's going to bring us to our main page in Westlaw. So from here, for the first query we did, decided to just go with plain language. So we went with child visitation of incarcerated inmates. With this, it's going to bring up certain things. As you'll see over here on the left, we have our cases, we have our statutes, regulations, secondary sources, a slew of resources that we can use. However, we notice here at the bottom that we have 3,380 results. This is too many results for us to go through. So with that, we thought about going into these cases. So first we went into the cases. And you're going to see in these cases that none of these are really quite up our alley of what we would like to do. So we have this Burkett v. WT, which you can see it's purple because we've already clicked on it. The problem with this is that it brings in enumerated sexual offenses. The issue here is that our client has not done anything sexual. He is not in jail for a sexual offense. The reason that's important is if we go to the statutes, something else we went to with this very first query, you'll see a lot of these aren't exactly the Indiana code that we need. So we realize that we haven't even found the right statute with the search term that we put in. So with that, we decided to take out of incarcerated inmates and just do child visitation and see what the Indiana statute has to say for child visitation. You can see there's 391. This also brought our total results up to 18,000. Far too many to be able to do. So going into the statutes, you'll see again that we're not in the Indiana code anymore. Now we're looking at West Annotated Indiana code. We have family law, custody and visitation rights. It's not what we're looking for. We have, again, family law. All of these are going to be family law. But realize that this is not what we wanted. So with that we said, okay, what would happen if we did prison visitation limitations? With prison visitation limitations, you can see our results came down quite a bit from 18,000. Now we have 20 cases and 54 statutes. Go into the statutes. It's always good, in my opinion, to try to find the law that you're using before you go into cases. So with that, we found this. We found 111139. This is Indiana Code. Clicked it. This is going to be Visitors Prohibition. And notice the confined person. As you can see, this is going to be from West Annotated Indiana Code, Title 11 Corrections, Article 11. Correctional Standards and Procedures, and then Chapter 3, Correspondence, Censorship, and Visitation. This brings us to Indiana Code 111139. From here you can see that the code is not very long. None of these codes really are very long. They're all broken up pretty well. But what it comes down to is you have paragraph alpha. It's going to say that a person may be prohibited from visiting a confined person, or the visit may be restricted to an extent greater than allowed under Section 8 of this chapter, something you might check out later. It's always a good idea if you have a link inside of what you believe you found to be useful to look at that and see what happens with it. Again, it goes on to say, if the department has reasonable grounds to believe the visit would threaten the security of the facility or program or the safety of the individuals. So department is going to be the Indiana Department of Corrections, as we figured out through more research. The statute goes on to say that in paragraph Bravo, the department may restrict any person less than 18 years of age from visiting an offender if the offender has been convicted of a sex offense, adjudicated delinquent as a result of an act that would be considered a sex offense, or the victim of a sex offense was less than 18 years of age at the time of the offense. Our gentleman, we don't have that information, but I'm going to go ahead and infer that he is not involved in being in prison for a sex offense. And so we're going to say that this subparagraph does not apply. It goes on to say in Charlie that the department prohibits or restricts visitation between a confined person and another person. That department shall notify the confined person of that prohibition or restriction. The notice must be in writing and include the reason for the action, the name of the person who made the decision, and the fact that the action may be challenged through the grievance procedure. We believe that the grievance procedure is the procedure we're doing right now, at least looking into this for the client. As you can see, he's a father serving a sentence in local jail, as we talked about earlier. The jail has refused, so this is the department, has refused to allow visitation as the administrators, so they would be aptly named in their written denial, believe it is security risks. So they've given reason. So they've complied with the law at this point. And with this point, it very much says in black and white that if the department has reasonable grounds to believe there is a threat to security or the program or safety of individuals, they can deny these requests. So as of right now, with the statute and the statute alone, the department is lawfully exercising something that's been granted to them, which is a denial of allowing the 6-year-old to visit his father in prison. So with that, we decided that we wanted to see if there's any case law out there. So we're going to have to go up here, because if we go back to the search alone, and we go to cases, the overwhelming issue with these cases is that a lot of them, and by a lot I mean almost all of them, have to do with the fact that there are sexual offenses, as you can see here, sexual offenders, or contested visitation. So you have the spouse or the other parental entity not wanting the child to visit the individual that's incarcerated. That's not the case here. As you can see in our topic, the mother has no objection, and we don't know it, but we're assuming the father's not in prison for a sexual crime. So with that, it's going to bring us back to our search, because we're not getting anywhere with these search terms. So then I decided to try to broaden it up a little bit, see if we can go with, well, I guess maybe not broaden it up, maybe specify down. A prison facility stops child visitation. With the prison facility stopping child visitation, you can see our cases came down to 21, so that's a much more manageable number to only have 21 cases that we can review. But again, looking through these cases, we have issues with people wanting to terminate the rights of the parent. We have issues with sexual crimes. We have issues that some of these cases aren't even about the person that is still in prison, that they're just out of prison, and now they want to see their kid, and they're trying to get a divorce decree modified, or something to that effect. None of this is beneficial to our client, or helping him at all. So with that, we decided, okay, so the law itself says the department that is involved. So that would be the Indiana Department of Corrections. So, decided to see what if anything, the Indiana Department of Corrections had to say on child visitation. This brought our case number back up to 77, and our statutes up to 53. The issue with this is that the words department and Indiana are far too broad for this to work for us. We're again getting into cases of child molesting, things like that aren't necessary. Going into the actual cases tab instead of the overview tab, excuse that, we get into these cases. They're going to be, again, Doe v. Donahue, prison regulating, prohibiting minors from visiting child sexual offenders. It's not what we're going for. We're not going for anybody sexual related. So we decided to take sex out of it. First, we're gonna broaden this up a little bit, see if we can get a little more out of it. As you can see, we're gonna have 53 statutes. So we added the words child visitation. So we'll go with, what if it's just visitation of a minor child? Maybe some language there may make this more interesting or more beneficial for us. Our cases came down to 26 from 77. I call that a win. The statutes went up 3 statutes, though, from 53 to 56. So with that, we start looking through. We get Burkett v. WT, which has potential to be good for us due to the fact that it's the Department of Correction directive restricting inmates convicted or adjudicated of innumerable sexual offenses. So, what happens where an inmate was not convicted of qualifying sex offenses? It's something we need to look into and keep in mind that Burkett v. WT, again, what I like to do, open link in a new tab so that way I can keep my search going, but come back to that later when I see if I can find something. And maybe something else will fit, or if, that way I can just read through the applicable cases that I think are going to be good for our client. So moving forward, we have 26 cases to go through. We're trying to figure out what would happen. Again, we're getting words like sexual offenders, things like that. So we decided to take sex out of it. And you can do this by going into the advanced, it's over here next to the search button. Go into the advanced and you can see all of the different modifiers you can use when using Westlaw. So with this, we went Indiana Department of Corrections, and then we decided to start using some of those modifiers. And visitation, with and minor child, without, that would be the percent sign, the word sex, with an exclamation point to say anything after it. Sexist, sexually, anything that could follow the X in sex. Then we're going to search that. So that killed us. It brought our cases back up to 2024. And the thing that we noticed is that this is the Indiana Department of Child Services, things like that are getting flagged and brought up in our search. So we decided that we don't want to use that anymore, because it's obviously not doing what we want it to do. So we got rid of IDC, Indiana Department of Corrections, and we decided to go with incarcerated. Brought us to 527 cases. Earlier we were hitting like 26, 31, now we're back up to 527, so something's not happening correctly. And with that, we realized that we're still getting dissolution of marriage, we're still getting things that we don't need. So we decided that maybe we should take marriage out of it. So we have sex, so now we're going to put out a percent sign for the word divorce, stopping it at the C and then putting an exclamation point to exclude any variation of the word divorce. It brought our cases down to 470. We also realized that we forgot to add the word denial. So we add denial and visitation, see what that does to our cases. It brings them down to 118. but that's still too many to go through. So what if denial and visitation were within the same sentence? That'd be the forward slash and the S. It brings our cases down to 11. Much better, much more manageable number to figure out exactly what we want to do and how we want to do this. The problem that we found is that almost none of the cases that we could find using these different searches either had to do with our specific fact pattern, or they were all red flagged and overturned, which is an issue if you're going to try to use the case in court. So, moving forward, trying to see if we can find any case that might be beneficial to us. Moving forward, we're seeing words like marriage decree, we're seeing other issues that aren't our issues. So we decided to take the word marriage out of it. What if it's not contested? What if it's not an alteration of a marriage decree because we have a mother who doesn't mind? So we tried to take out the word marriage. Put it up with M-A-R-R-I, with the exclamation point, not the percent sign, to see exactly what we can make out of this. It brought our cases down to 6. So we've gotten rid of all the cases that mention marriage. The problem with this is that every single one of these cases has been overturned. That's a problem. Going through these, clicking on them just to see what we can do with it, we read through and realized that this case doesn't work for us. This is talking about the paternal grandparents, so the father's parents. And again, it's molesting. And so this isn't what we want. We can roll right back, see if there's something else we can use in here. This is more about a surname and less about visitation. You can see the word visitation is not anywhere in here. Here we have visitation with his daughter. Reading through this case, it's not going to be good for our fact pattern due to the fact that this father apparently had this child out of wedlock, stopped visiting, stopped anything like that, and it looks like, if you read between the lines a little bit, that he was just trying to get visitation so he could modify his child support order. And maybe if he has visitation, he has to pay less, things like that. But he went years without talking to this child. Again, this isn't a problem because he's no longer incarcerated. So we had an issue. And that issue is going to bring us back to the tab that we opened earlier, which would be Burkett. So inmate petitioned for visitation with a minor child. It was denied, and the inmate appealed. So, as you can see, the Department of Correction directive restricting inmates convicted or adjudicated of enumerated sexual offenses from receiving visitors under the age of 18 did not apply to the inmate who is not convicted of qualifying offense, and the trial court was required to hold evidentiary hearing on the inmate's petition. This has potential. This is actually quite good potential to be a case that we could use in court for our client. And so, with that, we've gone through, shown you the multiple iterations it took just to get somewhere manageable, let alone something that actually was useful towards our case and fact pattern. You can see the different variations you can use in a search to make it honestly more complicated. It's more complicated to draft a search query like this, but at the same time you can see just how beneficial. We went from hundreds upon hundreds of cases down to 6 just by using specific words within sentences of each other, and making sure we took out specific exact words or even variations thereof using the exclamation point. So with that, we found law, we found a case, and after many tries, as you can see, it was not an easy process just to get where we wanted to, but I was quite relieved that it was so difficult, in that we got to display the different variations and different ways that you can use the search box, and all the different modifiers that you can put in the search. That was a really long pause. I apologize. The connectors and expanders, excuse me. So with that, if you ever need help with this, just go back to, let's say you're on the main page. You don't really know how to say what you want to say, but you know sort of what you want to say, just not how to type it out. You click the advanced button, you're going to come over here to connectors and expanders. You're going to start using all of those things that we used in our advanced search. With that, I hope you've learned something. I hope it was at least interesting, and this has been beneficial to you in some way. This has been our project. Thank you very much for your attention.